ZH Tanzania, Defence Secretary of State for the Home Department.
Mr. Gill.
My Lords, my Lady, I appear with Mr. Hawking for the appellant, Ms. Dodson QC and Mr. Nicholson appear for the interveners for the children. Ms. Cast-Frisk QC and Ms. Chan appear for the Secretary of State. My Lords, my Lady, in this case, the court is asked to set out the correct approach under Article 8, where the proposed removal of one parent will result in either the constructive removal of children, indeed British children from the UK, or will severely restrict contact between the children and the other settled parent. That question, the proper approach to Article 8 in cases of that sort, inevitably raises two matters. One is, how does one look at the best interests of the child? And second, how does one take into account the interests of the British child, which inevitably raises itself questions of how that child is to be treated as compared to other children. On the facts of this case, as your Lordships will have seen, the Secretary of State now and only now, at this very late stage, accepts that the Tribunal's decision and the Court of Appeal's decision, the Tribunal's decision was untenable, and the Court of Appeal should not have upheld it. Now, this is helpful, albeit late, and it may be thought to avoid a need to scrutinise the facts of the particular case. But the case has come before the court on the basis that the two primary points that I've set out are of such importance that the court ought to say something about them, bearing in mind the number of times that these issues are creating problems.
Well, I think our position, as you correctly identify, is looking for guidance from counsel on all sides, really, on the issues of principle that the case raises, now that the facts or the position of the individual has been resolved.
Indeed. I, for my part, therefore, am likely to say very little, if anything, about the third issue, as set out in the Statement of Facts and Issues, which is whether it's the right decision, in essence. But I do sound this note of caution. Divorcing such cases from facts can tend to lead to an losing of sight of how the issues of principle actually work themselves out in practice. The particular errors that were caused that were committed, we say, by the tribunal, therefore are matters which I do invite the court, for the various reasons that are set out in the printed case, to keep very firmly in mind, not least because at the end of my submissions I will be inviting the court to give some guidance going beyond what was said in EM Lebanon to what should happen in cases of this sort, because it's quite clear that the guidance in EM Lebanon as to the needs of the children to be considered and their interests to be properly considered and represented, clearly, as the facts of this case demonstrate, are simply not being fully thought about, indeed, perhaps by all of us. We're all perhaps learning about this.
Well, there is an additional factor in this case which wasn't present in EM Lebanon, which is the citizenship of the children.
That's right. That's right. Yes. My Lords, my Lady, the two broad areas that I'll therefore concentrate my submissions on are the best interest of the child and the impact on and the link with the question of the British citizenship of the children. One can't deal with the latter without the former, because these are children and we have to consider their best interests. And we say, as we have said in the printed case, in cases such as the present, the best interest of the child must be the paramount or primary consideration. Whatever the precise words that are used, it's clear from the jurisprudence that those best interests are to be given a special status. Now, developing that, what I will go on to submit is that the critical question, whatever you call it, whether you call it paramount or primary, the critical question really is this: what content do you give to the best interests of the child? And what is required in order to override it? Is it, as the respondent says, merely one factor, like any other factor, to be thrown into the scales and considered in the round? Or does it have some special importance? Is it, as we say, the first consideration, which can only, we say, be overridden once the decision maker has gone through a rigorous analysis of the best interests of the child?
But you're not pushing it to the point where it becomes a trump card in every case, are you?
I don't think I can say that it's a trump card in every case. We have not said so in our printed case. We recognise that there might be some circumstances where the best interest of the child may have to give way. The question really is, how do you in what sort of circumstances might there be where that situation arises, and how do you get there? The problem that arises with this situation, with the situation at the moment is, and this is the Secretary of State's position, that the best interest is treated as if it were really just, as I've already said a moment ago, just one other factor to be thrown into the scales. And then everything to be looked at in the round. They say in their printed case, they recognise it's a relevant consideration, but we say it's got a much greater power than just a relevant consideration. True, the language of the Strasbourg cases, indeed of other international cases, is to talk in terms of balance of competing interests and rights. But what do we mean when we talk about balance, and what does this tell us about the structured approach that we must take to the decision making? Well, what I hope to do is to show that all the Strasbourg cases are in fact consistent with the idea that once the best interests of the child demonstrate that the article of interest should not be interfered with, the burden is on the state to show a competing rights-based interest which can knock out those best interests.
When you talk about a competing rights-based interest, whose rights do you then ask us to consider? We're not looking, if it's a competing issue, it's not the children's rights, it's some other rights.
Yeah. We do not shy away from the fact that there might be circumstances in which competing interests of the broader community in cases of serious criminality might, in a given case, Una may be one of them, give rise to the interests of the child, best interests of the child, being overridden. It's not a balance where everything is looked at and then you stand back and make a judgment. It's putting the child center stage in the process, in the center of the ring, and then wait to see if something can knock out the interests of the child. And when one looks at the Strasbourg cases, although they don't all have, except in the more recent years, the language of the best interests, as Ms. Garsfrisk points out, although they don't have that language except in the more recent years, they're all in fact consistent with the proposition that I've just set out.
Couldn't there be cases where the best interests were themselves only arrived at on a narrow balance? Say this child has strong connections to Nigeria and to England. On balance, it would probably be better, but it's a pretty narrow balance. In those circumstances, would you give it the same weight as in other circumstances?
My Lord, I think that we would proceed on the basis that howsoever the best interests of the child are arrived at, the best interests of the child must be the dominant feature. Now, an appellant's interests, and that may encompass what your Lordship has just said, it may be that in some circumstances which may possibly only arise in the case of children who have been in this country for a very limited period of time and possess another nationality and possess close links with another country, provided the best interests are properly and rigorously analysed, there might be circumstances in which the best interests of the child are to be looked at in the way that your Lordship postulates.
Now, I think it would be helpful, if I may suggest, to know what the structure of your submissions is going to be, because you've set out very clearly the issues that we have to look at, but we have to have the context before us, the facts you no doubt wish to draw our attention to, and then we've got to look at the authorities and so on. I think it would be helpful if we knew how you're going to approach this so that we can, as it were, channel our thoughts along the lines that you want us to take us.
Well, my Lord, what I was proposing to do was to look at the importance of the best interests principle, look at the cases on paramount and primary, look at the Strasbourg cases, which then show how the Strasbourg court has approached this matter, and look at some international materials, which one or two academic articles, which indicate that the best interests of the child are interests which have to take centre stage and are not simply a factor to be put in the balance.
Well, you've set out in your written case at pages 3 to 9, I think, an analysis of the facts so far as we need to consider them, and you've given us references to the decisions below. Is there anything more that we need to pick up from that, or is that fully covered in the written case?
My Lord, the facts are fully covered in the written case, insofar as the other circumstances are concerned. Those facts are from page 53 to 59. Well,
paragraph 3 begins with, isn't
well,
it?
paragraph 94, and up to, I suppose, paragraph 102. That gives a bit more context to those facts. That sets out the father's situation in those paragraphs 94 to 102. But I think the court probably has the facts in
Yes.
sufficient control.
Yes, so we can really go pretty well straight away to the authorities, can we?
Yes, yes.
Well, that would be very helpful.
And after dealing with the best interests of the child, I was then going to move on to British citizenship arguments and finish off those arguments by referring to the case of Chen and drawing a comparison with the EC law in particular, and showing how not applying our approach leads to an unequal treatment between similarly placed classes of children, one of whom is the British child of a foreign national parent. But I'll come on to that in a moment. That's set out in paragraph 30 and 86 to 88 of our case. And then later, to finish off with a request for some guidance, I don't think I need to deal with the arguments about the position of the father. I've drawn your attention to the relevant paragraphs which set out the facts relating to him. The reason why I don't think I need to deal with his position now is because the Secretary of State concedes the case on the facts.
Yes.
So guidance for hearing the children's voice and so on, a few words on that, which Ms. Dodson will say perhaps a little bit more about. My Lords, so far as the proceeding, I think in that order, and I think I can probably cover it in less time than we actually indicated to your Lordships.
Good. Well, let's look at the authorities.
Yeah. The My Lord, before turning to the authorities, can I just draw attention to paragraph 22 of our printed case? Which is what we say encapsulates the end position. Whilst the language of the various instruments varies, it's clear that when those international instruments refer to the best interest being a primary consideration, they're simply acknowledging that whilst the best interest must be paramount or the primary, there may be other considerations. It's only in the most exceptional circumstances that the interests can be overridden. And we say the Strasbourg Court has now, post the Lisbon Treaty, in a very recent case, accepted this, and that's the Newlinger case. But looking at the authorities, my Lord, the easiest way we can do this is to go straight to Newlinger and then cross-refer from there to certain other authorities. Newlinger is at volume 3 at tab 56. Because this, in fact, sets out the previous international instruments. Now, this is volume 3, tab 56. This is a Hague Convention case and abduction case, but there are a number of parts of this which we say are entirely in accord with the approach that should apply in an expulsion case such as ours. The court at paragraph 49 on page 19 looked at the concept of the child's best interests. Generally, they didn't link it to anything to do with the Hague Convention at all. You can see, for instance, over the page at page 21, top right-hand corner, section B begins the Hague Convention. And then they begin on page 23 at para 58, considering the best interest in the context of article of the Hague Convention. But what they set out at paragraph 49 is a general position.
I mean, in a Hague Convention case, I mean, there's no immigration control interest whatsoever.
I understand that, yes.
I mean, you might, if you carry this to extreme, you might say that it governs whether you should send a woman to prison for her as well.
Well, entirely, my Lord, and the South African Constitutional Court has looked at the best interest in precisely that way.
But you say this case is going to tell us that the best interest of the children is the overriding interest. So, I mean, you're not surely going to say, and that would apply no less, not only in the immigration context, but in the criminal penal context.
My lord, in the criminal penal context, the case of M versus the state, which is in a small extra tab of authorities, 2 extra authorities, which were put before the court this morning, they're loose and treasury tagged, deals with that, and that would be the approach that I'd invite you to adopt in that case. But I'll come on to that in a moment.
All I really want to do is, so to speak, put down a marker that, that fine, of course we must look at this case, but bear in mind that it doesn't have other interests apparently in play at all.
Well, I understand that, my lord, but I'll explain why it has a relevance in a moment. Now, the court started off at paragraph 49 by looking at the Declaration on the Rights of the Child of 1959. And you'll see that there they referred to the child shall enjoy special protection, shall be given opportunities and facilities by law and other means to enable him to develop physically. So the special position of the child, the need for take a special position is set out. And they say, in the enactment of laws for this purpose, the best interest of the child shall be the paramount consideration. Now, the cross-reference for that, for the it's tab 41 in the second volume of authorities. And perhaps if I could look at these things together. And volume 2, tab 41. Principle 2 is set out in the way that I've just read it. It also contains a principle 7, which says in the second para of that, the best interest of the child shall be the guiding principle of those responsible for his education and guidance. The responsibility lies in the first place with his parents. Going back to Newlinger, the court in Newlinger at para 51.
It's quite interesting. Principle 3 is also of interest.
My lady, yes, we referred to that in the written documents, but I'm rather skated over, didn't refer you to it, I'm sorry to say, in the oral submissions. But that emphasis upon nationality is particularly important in the case of a child, because it then ties into the enjoyment of certain other rights which are the international community regards as being important for the child. We ourselves have taken the same approach, as has the European Union in its various documents about the importance of citizenship and the importance of encouraging children to be good, proper and contributive citizens.
There's quite a lot in Principle 6 too, which is relevant, isn't there?
Yes. Wherever possible, grow up in the care and the responsibility of his parents, wherever possible. In any case, in an atmosphere of affection, moral and material security. Child of tender years shall not, save in exceptional circumstances, be separated from his mother. Society and the public authorities shall have the duty to extend particular care to children without a family and to those without adequate means of support. So the international community is recognizing that states should owe a very special duty. When one looks at, therefore, Article 8 rights, one looks at it from the context of a situation where the international community has recognized that the recipients of these rights are not just any citizen in particular. The recipient of these rights is a child citizen, and therefore the Article 8 right to a private and family life attracts a much greater importance. The Article 8.1 interests become extremely important, much more so in the case of a child, much more so in the case of a citizen child. And the best interests of such a child therefore attract therefore really do require something pretty exceptional to override them. Before going back to Newland, can I just ask you to turn to the following tab, which is tab 42, which is the CEDAW 1979 Convention on Elimination of All Forms of Discrimination Against Women. Now, the two particular parts of this, although again there's quite a lot of this in the preamble, the two particular parts that I want to refer to are Article 5b, which says that to ensure that a family education includes a proper understanding of maturity as a social function and recognition of the common responsibility of men and women in the upbringing and development of their children, it being understood that the interest of the child is the primordial consideration in all cases.
Basic stuff.
At Article 16, says states parties shall take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations, and in particular shall ensure on the basis of equality of men and women, and then D, the same rights and responsibilities as parents, irrespective of their marital status in matters relating to children. In all cases, the interest of the children shall be paramount. So and then tab 43, which is the 1989 New York Convention on the Rights of the Child. The preamble is particularly important.
Well, this is the most important instrument, surely, of the
Yes.
international ones, because it's a binding instrument. The Declaration's not binding, but the Convention is.
True. But I was referring to the Declaration to sort of give an idea of what we mean when we talk about primary. This convention recognizes at indent the fourth recital, recalling that in the UDHR, the UN has proclaimed that childhood is entitled to special care and assistance. And next, convinced that the family is the fundamental group of society in the natural environment for the growth and well-being of all its members, and particularly children, should be afforded the necessary protection and assistance so that it can fully assume its responsibilities within the community. Those aims and obligations, aims of what follows, indicate exactly why it is that the that decision makers must, when applying Article 8, even in an expulsion context, consider these obligations, the special care and attention that must be given to children. The recitals continue in the same vein, but further down where it says, bearing in mind that the need to extend particular care to the child has been stated in previous other conventions. That also underlines the point about the special status accorded to children. Then again, bearing in mind that, as indicated in the Declaration of the Rights of the Child by reason of his physical, mental immaturity needs special safeguards. Having set out those sort of points, they say in Article 3, having importantly made the point in Article 2, that the rights have got to be secured without discrimination of any kind. We'll come on to that later. They say in Article 3, in all actions concerning children, whether undertaken by public, private, social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest shall be a primary consideration. And then, things to ensure such protection care is necessary for
we see there
well-being.
the indefinite article. Principle 2 in tab 41 said the paramount consideration. Now we get a primary consideration.
I'll explain why that came about by an article which talks about the travaux on this.
Oh, I see. Right, thank you.
And then at Article 9, it says, again, states parties shall ensure the child shall not be separated from his or her parents against their will, emphasizing the need, therefore, to take into account the views, well, certainly feelings, wishes, and if the child is capable of expressing views, except when competent authorities, subject to judicial review, determine, in accordance with applicable laws and principles, that such separation is necessary for the best interest of the child. So that separation may be tolerated if it's in the child's best interest, but this would seem to suggest that states shall ensure that otherwise there is no such separation. Such determination may be necessary in a particular case, and it gives examples. And then 9.2, the need for all parties to be given an opportunity to participate and make their views known, which simply didn't happen in the case of these particular children in this case. And again in 3, shall respect the right of the child who is separated from one another to maintain personal relations, direct contact with both parents on a regular basis, except if it is contrary to the child's best interests. 12 is also important. This goes over into the point about the need to consider the views of the child, where the child is capable of forming his or her own views. And the need in Article 12.2 to ensure that administrative proceedings, judicial proceedings, are therefore tailored with that in mind. That might have some impact on what happens about future training of judges in the tribunal system. Article 13 is also important about the freedom of the right to freedom of expression. What this convention then does is to set out a range of other rights. And at Article 18, it says, states parties shall use their best efforts to ensure recognition of the principle that both parents have common responsibilities for the upbringing and development of the child. Parents, or as the case may be, legal guardians, have the primary responsibility for the upbringing or development of the child. The best interest of the child will be their basic concern also. Now, that may not always happen, of course, in some situations, in an expulsion contexts, interests of the different parties can vary. And so the tribunals have to be alive to that. But leaving the convention there for the moment, and then going back to Newlinger. Newlinger then says at paragraph 51.
Sorry, just remind me of the tab again, please.
Tab 56, volume 3, tab 56.
Thank you.
Newlinger then goes on to say at paragraph 51 that although this concept of the best interest hasn't really been developed, nevertheless, it does say the committee has emphasized halfway through paragraph 51, Committee on the Rights of the Child, on various occasions the convention must be considered as a whole, with the relationship between the various articles being taken into account, and any interpretation must be consistent with the spirit of that instrument, must focus on the child as an individual having civil political rights and feelings, opinions of its own. And then it refers to the trying to give a little bit more context to what the best interests mean to UNHCR's guidelines, which are set out in paragraph 52. It also refers to, again, trying to give a bit more content, paragraph 53, to the 1979 convention that we've just looked at, Article 5 and Article 16 in particular. And then at paragraph 55, it goes to say, even though the principle, the best interest, doesn't appear in the ICCPR, the Human Rights Committee, in its general comments, 17 and 19, has referred to the paramount interest of the child in the event of separation or divorce of its parents. Now, those comments are in volume 3 at tab 60 and 61 in the same volume. So if you can just, before proceeding further with Newlinger, just consider those. At tab 60, the Human Rights Committee says this, Article 24 of the ICCPR recognizes the right of every child without any discrimination to receive from his family, society and state the protection required by his status as a minor. So it is drawing particular attention to the importance of the status as a minor. And then in paragraph 2 at tab 60, in this connection, the committee points out that the rights provided for in Article 24 are not the only ones that the government recognizes for children. And then it begins to elaborate that. Of course, the Convention of the Rights of the Child is more specific. It goes on. The bottom at 4. All of this it's short, all of this is worth reading, but in particular at 4, the right to special measures of protection belongs to every child. This is not drawing any distinctions on grounds of nationality or whether this is an expulsion case or not, because of his status as a minor.
Sorry, I'm lost. Where are you?
This is tab 60. Tab
60. You said 61.
I apologize. Tab 60.
Yes, right.
I'm just referring to paragraphs 1 and 2, and at the bottom at paragraph 4.
Yes.
And then at 5, the covenant requires that children should be protected against discrimination on any grounds, including nationality, which would require pretty, as we know from cases that don't bear citing anymore because they're so well known, would require very weighty considerations if that such discrimination were to be justified. And it goes on at paragraph 5 to say, to include these words at the end, including, it refers to ensuring that measures of protection are aimed at removing all discrimination in every field, particularly as between children who are nationals and children who are aliens. So that'll become important when we consider the Chen argument in particular. And I think, although
That would logically be the opposite of your submission, isn't it?
well, no, the submission is that they should be removing discrimination in the way which they treat children who are British citizens who have derived their nationality through a British parent, on the one hand, and children who are long-term, who are long-term settled, but have not derived their nationality not derived their British nationality through a parent. Can I?
But this appears to advocate a much more radical principle, namely that you ignore nationality, you look at presumably substantive factors other than nationality, and I think you say with some force that that's ignoring a relevant factor.
My Lord, that's yes. What our submissions lead to is that to the extent that there is room for some exception to be made to the best interest of the child, where the child is a foreign national, there certainly isn't any room in the case of a child who is a British national.
Well, we've got to look at the context in which we're asking the question, haven't we? If the context is immigration control, it stands to reason that nationality is a pretty important factor when one's looking at immigration control. Yeah. And that one may be able, in that context, to distinguish between children who have a right to be here and children who don't. That must be the case, mustn't it?
Well, bearing in mind that I've accepted that the best interest of the child as a general principle could in some circumstances be overridden, there may be some circumstances that might arise in the case of a foreign national child who has been in this country for a very limited period of time, but the parent has committed gross acts of criminality. Bearing in mind I've accepted that, we say that where the child happens to be a British citizen, the factor of citizenship and all that comes with it gives to the best interest of the child a greater impetus, which requires something even more significant to override it if it is to be overridden at all. And whilst the starting point is this position that one seeks to try to eliminate all discrimination between children who are nationals and children who are aliens, where the interest that the Secretary of State seeks to protect is the interest of the state and the wider community, such as the interest of the public to be free from serious criminal risks. In those sort of circumstances, there may possibly be a basis for the Secretary of State to say that in the case of a foreign child who has only been here in this country for a limited period of time, that child may have to be treated a little differently to a British citizen child. But where the foreign national child has been in this country for a long period of time, has been effectively settled here, the Strasbourg case law demonstrates that there's really no distinction between such a child and a child who is a British citizen, or even if the British citizen child has not in fact been here for any particular period of time.
I wonder if I might ask whether, in your submission, the nationality of the child has an independent value beyond as a contributor to the evaluation of the best interests of the child.
My Lord, we do say that it does have an independent contributive value, because irrespective of the best interest of the child, the possession of nationality is in itself is a right which is extremely important to any person, and particularly to a child. And so even if a best interest analysis, such as the point that my Lord Mance was putting to me, that it may possibly be in better interest of the child for the child to go abroad, even if that were to be the case, if it's a British child, the possession of that nationality has to be given some special consideration independently of the best interests.
You see, I think in the context of the best interest of the child, there may well be room for debate as to the validity of discrimination. But I wonder whether in this case one needs to get embroiled in that debate. Presumably your submission is that it is in the best interest of these child, independently of their status as British nationals, that they should not be removed, but that superimposed upon that in a different context, because they are British nationals, that also ought to weigh in the balance.
My Lord, absolutely. That is putting the submission that we've been trying to set out in the case succinctly.
Isn't that just another way of saying that it's in their best interests? I mean, it is generally in the best interests of someone to know and grow up and belong, in a practical sense, to the country of which they're a nationality, I would have thought.
And the contrast is between that and being, in effect, forced into exile, isn't it?
The contrast certainly is that, but the point that your Lordship puts to me that it is, on one view, part and parcel of a best interest analysis. Yes, it can be part of a best interest analysis, but what I'm saying is that there may be circumstances where the best interest analysis leads to some other conclusion. But here, the child may say, well, everybody else has said my best interests lie elsewhere. I shouldn't be allowed to remain here. But hold on, I actually possess a British citizenship. That is important from my perspective, and that in itself, whatever you may say about my best interests, is something that I say has an independent value of its own. The child may take that view. So even though it goes back, I think, to the point that Lord Mance was putting to me before, that best interest may encompass
But why does it have a value, nationality? I think if you ask that question, you're likely to get back to the practical significance of nationality, which is an element necessarily of best interest in the wider sense.
Well, if you put it if you look at it in that way, then my submission only marries with that if the package of rights that comes with nationality, all the benefits that come with nationality, are actually given a supervening weight, and they're actually given that degree of respect.
What is it, though, that goes with nationality? Does one get some hint in paragraph 8 of this declaration? That, this is tab 60, paragraph 8, when the second sentence says the purpose of this provision, this is the right of the child to acquire a nationality, is to prevent a child from being afforded less protection by society and the state because he is stateless. Now, of course, we're not dealing here with people who are stateless, but is it, if you have a nationality, does that carry with it some connotation of having a state that will look after your interests? And so long as you're in the state, you get the benefit of all of that. Whereas if you go into exile, then you're moving to somewhere that doesn't have that kind of responsibility for your welfare.
Well, it means that, but I think it also means more. It also, it's not simply about having a state that can protect your interests in that sort of way, but the possession of nationality carries with it not just obligations that the state owes to you, but your own separate entitlement to be within that particular state.
So it's a right to choose where to live, and if you say, well, I would like to live in the state to which I belong, that's a factor which goes along with nationality and is a legitimate point to make. Is that the point?
My lord, yes, if the child is a person who is a national of this country, has the right to demand from the state that he be allowed to remain. The state can't expel him. This is a clear principle of international law, and we know this, and it is cited in a printed case, Van Dyne, ECJ, that the state cannot expel its own nationals. It must allow them to reside.
Yeah.
The reference to Van Dyne, I think, just to give you the reference, I don't need to turn it up. It's volume 3, tab 57 at paragraph 22. Now that principle, once that principle is recognized, it's not simply about the citizen saying, well, the state has a duty to protect me. The state has a duty to provide me with all this package of rights, with all these rights which will enable me to develop and have a fulfilling life and so on. It's not simply about that. It's about the national saying, whether you do that or not, the fact is, or whether you do it to an extent that I like or not, is not the point that I'm asserting. The point is, I've got a right to choose to be in this country. It's the contract that the national makes with the state. If nationality is seen in terms of a contract between the state and the individual. So the very factor of possession of nationality will add a separate dimension. Yes, it can be seen in the way my Lord Mann says, as being another aspect of the state's duty to protect and so on. But it doesn't deal with the other side of the equation, that on the one hand there's a state's duty to protect, on the other hand there's the individual's duty, individual's right to be able to assert that nationality even where the protection isn't what you would like it to be.
I mean, I suppose there's this too. I mean, if you take British children and send them off to Tanzania, I mean, presumably the Tanzanians don't owe them the same duties as natives of Tanzania.
Well, clearly there won't be duties in terms of things such as diplomatic or consular protection or matters of that sort, but it'll probably go even further than that. In many other states, such persons will have difficulties in acquiring certain types of
I mean, that's the only point I was making. I mean, for what it's worth, in your favour, there is that aspect.
Now, Mr. Gill, I think we were really looking at paragraph 55 of Newlinger, and we got to tab 60. Yes. But there is another general comment as well, isn't there? Was it 61 that you wanted us to look at?
Yes.
Tab 61.
Yes.
Is there any particular passage here which is likely to help us?
Well, I think it should have the reference to sorry to say, it should have the reference to paramount, but I don't appear to have.
It seems to be largely, in contrast to general comment 17, which is very tightly focused on the position of the child.
Yeah.
This is looking at the relationship between the spouses, is it? Marriage.
Yes. The reason for citing this, but I can't seem to
it's paragraph 9 refers to paramount.
Ah, yeah.
Yes. Yes.
Yes. Yes.
That again is in the context of discriminatory treatment, is it?
Yeah. Any discrimination in regard to the grounds and procedures for separation or divorce, child custody, maintenance, alimony, etc. So those sort of issues, the paramount interest of the children is important.
Yeah.
So what they were signalling in New Linga was that these two comments do refer to the need for paramountcy in that sort of way, and General Comment 17 also talks about discrimination and is more important for my purposes. At paragraph 56 of New Linga, the European Union Charter is referred to in Article 24. Now this comes in December 2009 and has the words that children shall have the right to such protection and care as necessary for their well-being, talks about expression of their views, and then 2, in all actions relating to children, whether taken by public authorities, the child's best interest must be a primary consideration. And you've seen 3 as well, right to which I've already read out. Now, having set out that context, the court then begins to turn to the Hague Convention and look at those matters in particular.
Where do you find the EU Charter?
The EU Charter is at tab 45. Perhaps if I just finish off on this, at tab 44, before going to the European Charter, is the African Charter, and that does talk at tab 44, volume 2. The African Charter does talk about the primary consideration in Article 4. And at tab 45 is the European Charter.
I'm sorry to be obtuse. I mean, why are we looking at the African Charter?
What I have submitted in paragraph 22 of our printed case is that although the language of the various international instruments uses different words, some use primordial, some say paramount, some say primary, or some say the primary, when one actually looks at all of them together, they're really putting forward one idea, and that idea is drawn out in New Linga.
Yeah.
In a passage that I'll come to in a moment. But the Charter is at tab 45.
We're looking at Article 24.
That's right. But that's... we have the context...
We're back to the indefinite there, aren't we?
Yeah. Well... Lords, if I can go back to New Linga and go to paragraph 131. The court there, at tab 56, volume 3, the court there, at paragraph 131, recognises, in setting out general principles, that the ECHR can't be interpreted in a vacuum. It has to be interpreted in harmony with other general principles. And this is a post-charter case, post coming into force of the charter case. It then says at paragraph 132, in matters of international child abduction, Article 8 imposing contractual states, the obligations that Article 8 imposes on contractual states must therefore be interpreted, taken into account, in particular the Hague Convention, for instance. That principle is quite clear and is that you take into account other instruments. More importantly, at paragraph 135, the court notes something quite important. It says the court notes that there is currently a broad consensus, including in international law, in support of the idea that in all decisions, whether they be Hague Convention or otherwise, in all decisions concerning children, their best interests must be paramount. See the numerous references in para 49 to 56, which are not to do with Hague Convention at all, and in particular, the Charter. Then at 136, the child's interest comprises two limbs, and here they begin to try to give some content to what that interest is. And from that they say, follows that family ties may only be severed in very exceptional circumstances, that everything must be done to preserve personal relations if and when appropriate to rebuild the family. And I'll be saying the Strasbourg cases, previous cases, although they don't use this language, are in fact consistent with this. And then at 137, the same philosophy, so this is a general philosophy, the same philosophy is inherent in the Hague Convention. This is not a case which is therefore restricted to Hague Convention at all. The point being made here is of general application. And then it says that, also in 137, in other words, the concept of the child's best interest is also an underlying principle of the Hague Convention. 138, it follows from Article 8 that a child's return cannot be ordered automatically or mechanically when the Hague Convention is applicable. Then it begins to set out further the best interests. So far as 134 is concerned, it should draw attention to that. In this area, the decisive issue is whether there is a fair balance between the competing interests, those of the child, the two parents.
Which paragraph are you reading?
I've been asked to read from paragraph 134, which Scarce Risk would like to draw to the court's attention.
Well, it talks about the fair balance, but then it goes on to say that, however, the child's best interest must be the primary consideration.
And it cites the previous cases, as is indeed apparent from the preamble to the Hague Convention, etc. The child's best interest must, depending on their nature and seriousness, override those of the parents. So the language of the primary, paramount, primordial, and the need for something to override it, whether it be the interests of the some competing interests of the parent or of the public or order. That's the analysis that is coming through, not a general throw everything in the balance and look at everything in the round. That's not the approach that is here. And
the comment about the child's best interest being the primary consideration is followed by a passage showing that they're considering the position as between parent and child, for example, in custody, isn't it?
well, yes, but that doesn't. It's not inconsistent with the point that I'm making. Paragraph 135, in fact, and what the other paragraphs that I've read out do indicate that they're looking at a general principle. How the general principle will then apply in a particular field will admittedly, may admittedly vary. But you start off from the best interest of the child. That is the primary, or whatever phrase one wants to use, a primary even, and then look to see whether it can be overridden in some way by some competing interest. In an immigration or expulsion case, as I've said, and I'll show you the authorities in a moment, all the Strasbourg cases proceed on the assumption that it is only going to be some pretty serious types of future threat to public order, and not just the general interests of immigration control in the round, that will be capable of overriding the best interests. It then goes on at paragraph 139, giving a little bit more idea as to what approach the domestic courts must take. In-depth examination of the entire family situation. Now that's also important in an expulsion context. it then sets out the applications of those principles to the present case, which was a Hague Convention case. But when it begins to do that in 141, what we see is that in fact it brings over the principles that are coming from expulsion cases. We see that from paragraph 145, for example, and 146, where there is citation from Maslov and Una. I think Emery also, which are all cases in an expulsion context. So they're looking at best interests in that way, giving it primary importance. It's 145.
I mean, 146 is reference to our old friend Una in the Netherlands. But, I mean, by that stage, all it's saying is that these are obviously important considerations, but they don't, at that point, put them as decisive.
Yeah,
That's and that accords with your submission. You're not saying in a immigration context that the child's interests are decisive. Of course, on certain cases, they're highly likely to tip every balance, but not invariably.
My Lord, yes. Now, just finishing off on this, there is a in the supplementary authorities bundle.
The first, is it
The first
bundle-headed
supplementary
first?
authorities
Is it the
bundle.
first one?
Yes.
Yep.
Lord, yes. There is at tab 86 a article which from Jane McAdam, well-known writer in this field, who deals with the position of asylum-seeking children. And at at page 253, she begins to look at the Convention on the Rights of the Child. She says the CRC establishes, under heading C, establishes a protection framework of nearly universal acceptance, having been ratified by every state except Somalia and the USA. So it's achieved that degree of international acceptance. Furthermore, the CRC does not permit derogation from any of its provisions. And you see the next sentence about the implications for child rights. It then, at D over the page, begins to deal with the, just to, I don't want to read it, but just to deal with the best interest of the child. The passage that I want to, it bemoans the sort of, the failure of people to give content to this when it says at the bottom of 255 the indeterminacy of the principle. But then more importantly for my purposes, at the bottom of 256, at E, it says this: although states must regard a child's best interest as a primary consideration, Austin argues that the Travaux Pro Charge of the CRC revealed unanimous support for the clear principle that the phrase should not be interpreted in any way as a rejection of the overall principle that actions should always be taken in the best interest of the child and the taking into account the child's rights. He maintains that the indefinite article was selected in preference to the purely to ensure sufficient flexibility, at least in certain extreme cases, for taking competing interests into account. Now, 257, reference to the important case of Wu in Canada. then says, also goes further, arguing that whenever other interests are to tip the balance away from a decision in the child's best interest, the burden of proof will rest on those seeking to follow that approach. That's entirely consistent with the language of Baltif and of Article 8.2, showing that the burden is on the state to show that it is necessary to interfere with Article 8.1 interests.
That phrase, show that no other acceptable alternative exists.
Yeah.
Is that helpful as a test?
I was drawing attention to that sentence for the burden of proof argument. Now that Your Lordship asks whether that phrase is acceptable, whether that is helpful, we still need to see what is acceptable, by what standard do we define acceptability. And it doesn't help in that sense. The content of what is required by the best interest of the child still, therefore, needs fleshing out. And that's what I think everybody's struggling, or the writers in various courts have been struggling with. And because it's been difficult, they've tended to just leave it.
Surely is it a problem about the content of what is in the child's best interest? It's a problem about ascertaining what other factors might outweigh what would otherwise be in the child's best interests, and presumably the other factors here we're talking about are factors like immigration control.
Well,
possibly the desirability of removing someone for other reasons, commission of offences, that sort of thing.
Well, if that's what it's getting at, then my submission is that it is not immigration control in itself which can justify deportation or removal action. It's got to be something much more serious than that. But even then, one has to look at acceptability in perhaps a context of saying, can one adopt a less interfering measure? Can one adopt a different approach?
What about the quotation from Wan, the Minister for Immigration and Multicultural Affairs, the Australian case, halfway down 257?
Yes.
You can see that what the court said was, first of all, identify what the best interests of the children required. So that's stage one, and you say one has to concentrate and identify what those are, and then assess whether the strength of any other consideration outweighed the consideration of the best interests understood as a primary consideration.
That's right.
Is that a helpful way of summarizing the exercise?
That's the approach. It's that paragraph that we say the court should adopt. It starts off at the start by saying the archetypal extreme example concerns the competing rights of mother and child, where there are complications of childbirth. And I think that may have been an example given in the Travaux, but I accept that there may be others. But simply saying that there are immigration control considerations isn't enough. You've got to set up competing rights.
Well, except it's precisely what this passage does say is enough. If you look a bit higher, in the second paragraph, or the first fresh paragraph, about 6 lines down, it says the question will therefore be whether policies such as immigration control may legitimately outweigh the child's interests in the particular case.
Well, let me explain what I mean then by that. Immigration control is not just a general phrase which doesn't have content. Some types of immigration control, such as the exercising immigration control in order to protect the public at large, that is the sort of consideration which will justify interfering with the best interest of the child. And cases like Una exemplify that. In Una, which we'll come to in all the other cases, Baltif and so on, it's not the fact that the person's overstayed or they've breached immigration protection rules and regulations. The thing is that they have breached it the requirements of immigration control go further than that. One of the requirements of immigration control is the need to protect the public. And it's the protection of the public as a facet of immigration control, which is what could, in a serious case, begin to override the best interest of the child. Not general immigration control.
Well, Ms. One sooner or later in the next 2 days, we've got to face up to a case such as this one that I'm now going to put to you. Assume that some woman comes over from, doesn't matter where, Tanzania is here, and she lies her way in, she does everything contrary to immigration control possible to do. But in order to improve her position of staying here, when all these efforts to evade immigration control were going to come to light, she selects somebody settled here to father a child. Having fathered the child, disappears off the scene, and there is this woman with this child who happens by that fact to be a British citizen. And it's 6 months old, and the question arises, can they remove this woman? What's the answer? Out of the question because it's not in the child's best interest, or is that a possible scenario where you could remove the mother with the child?
We say it's not a possible scenario.
It's what?
It's not possible to remove
Not
them.
possible.
No.
So that all the woman has to do is that, and then she's immune from immigration control.
Well,
I don't think all has to do is that, really quite encompasses everything that is involved in having a child.
it's not
a straightforward thing to do.
It's, my lord, one of the other things is this, that not everybody goes through that situation.
No.
It tends to be, in fact, a little bit more limited than one thinks. And even when a woman has done what your lordship postulates, one cannot ignore the fact that after the child has then arrived on the scene, with all the bad faith of the mother, if there is a bond between mother and child, if that family life is there and it is in the best interest of the child to have the mother there, and also in those circumstances one can't ignore the fact that family life is going to develop further. Just because someone's behaved badly in creating the family
I
life.
absolutely, within this example, I postulate an absolutely close bond, mother and child, and that if mother is indeed deported, removed, the child will, if you like, be constructively removed, because inevitably the child would go too.
Yeah.
I postulate that, and I simply ask, yes or no, is that a situation in which the Secretary of State could, in the interest of immigration control, say, although the child is a British national, a British citizen, she must go.
We say clearly the Secretary of State could not do that. And a case that I'll come to is the case of Chen, which arose out of the problems in Ireland precisely because of the concerns that your lordship has raised. European Court of Justice held, no, never mind the bad faith or the abuse, deliberately going to Ireland to have a baby there, get the baby to have Irish citizenship in Northern Ireland, and by virtue of the Irish citizenship, the child had European Union citizenship, the right of residence, that even without any movement, that the child attracted as a result of the possession of Irish nationality was so important, and that it could only be made effective, that right of European Union nationality could only be made effective by having the mother there. The European Court of Justice threw out Mr. Plender's arguments on abuse. That led to the Irish state changing its law to say, well, you can't just come onto Irish soil and by virtue of birth on the island of Ireland acquire British citizenship. The problem was one created by jus soli. Now, and Lobe is another pre-Chen case, which the other side rely upon, an Irish case, which is the same problem. But Chen demonstrates how important it is where you have given rights of citizenship to a child, whether it be rights of European citizenship or British or whatever, you actually make those effective. And if that means letting a legal entrance, so they were legal entrance, the parents in the Chen case, if that means letting a legal entrant parents stay, who have knowingly and have openly said, we knowingly did this. When the European Court recognizes the child's rights to development in the presence of the mother, one sees how important it is to understand child rights in this way.
Can I just ask a question? Leave aside in Lord Brown's question the British nationality, assume that the child was with someone who was also a foreigner. If your principle is right, you should look first of all at the child's best interests. Now, I'm just interested to know how far in practice does that go? I mean, do you say a child born in this country is going to have all sorts of advantages, or are we? Do we treat all countries similarly? It's quite obvious if you go to somewhere like Tanzania that opportunities are completely different from here. And I just wondered, in practice, would the child's best interests, if they came first, would you say, well, any child who lives here, an awful lot of people would like to live here, and any child who lives here is likely to have a much better future, on one view. I hope it's not an unduly insular view, but would that be a legitimate argument, or in practice is that sort of argument ignored?
Our position is that that argument is a legitimate view to take, and one can't ignore that argument. I know that there's a great deal of debate about cultural relativism and in this regard, but one needs to try to make the rights of the British child effective in this country.
Well, you're slightly begging the question, because I was
foreign national child.
Assuming it was not a
foreign national child.
Yes.
To make the rights of the foreign national child rights to which the international community says should be accorded to every child. It is important that those rights be made as effective as possible. And if that means that we recognize that the child's rights and interests are best served by staying here, having access to benefits here, having access to support systems, care systems, education systems, welfare systems, if we recognize that the child's interests, rights and interests will benefit from all of that, and that is where the child's best interests lie, then so be it. It may be that the arguments to do with cultural relativism may well have to work on an individual case-by-case basis, and in EM Lebanon, one starts beginning to get some of the problems that might arise. But even there, the court came to a particular view, which meant the child would stay here.
Now, we're looking at Jane McAdam's article. Is there anything more to be taken from that?
No, it was that passage in the middle of. That's right.
Yes.
Do we have Philip Alston's work from which he quotes about the Travo?
It's not in the bundles. It arrived far too late yesterday, I think, by email for it to be. But if I can get hold of it and ensure copies are available.
Well, I think it would be, if it's available, it would be very useful to have it.
It would be helpful if you can.
I think
There appear to be two, one in 1991 and one in 1994.
Yes, the
Yes.
94 one was a...
94 one, I think, might be.
Perhaps the 91 was dealing with the travellers.
Yes. 94 is a book, I think, that he edited, yeah.
There's an interesting, there's a footnote 12 on the tensions between immigration control and child welfare. See Baba, is it? Minors or aliens? Have we got that? It's a book, it says. Yeah, maybe we haven't got that. Yes, it is a book. It's page 293 to 99.
Yeah. Well, it's in the European Journal of Migration and Law, actually. Is it, do you think it may be an article? Then,
Yes, it might be.
No idea. Jacqueline Barber's written a great deal about this subject
Yes.
in many different places, so...
Well, I'm not sure that I've seen that article by Jacqueline Barber. There was something that the ladyship quoted, I think, in a lecture, which is well known, but I don't think I've seen this one.
well, for the time being at least, can we put a bid in, please, for Alston's
Yes.
1991
Yes,
work? Well, so we can put aside for the moment Jane McCann, can we?
my Lord, yes. Can I just say, a little bit more quickly, ask you to look at general comment number 6, which is at volume 3, tab 62.
Yeah.
This is on the Committee of the Rights of the Child. There are, on the point that we've just been discussing, it's paragraph 86, so volume 3, tab 62, paragraph 86. And here it says, exceptionally, a return to the home country may be arranged. So this is dealing with foreign children. After careful balancing of the child's best interests and other considerations, if the latter are rights-based and override best interests of the child. Such may be the case in situations in which the child constitutes a serious risk to the security of the state or to the society. Non-rights-based arguments such as those relating to general immigration control cannot override best interest considerations. But a certain sub-facet of general immigration control, that is the need to protect the public, might, as cases like Baltic and Una
This is in relation to unaccompanied separated children. I mean, is this our problem?
No, but the principle that is encapsulated here is what is important. What they're saying is that where you've got such a child, unaccompanied child, a separated child in this country, foreign child, you've got to still take a certain approach. That is, you look at the best interests and other considerations. If the other considerations are rights-based and override the best interests of the child, then you can remove that child.
Would you say, I mean, is it a fair description to say that general migration control is non-rights based?
Yeah.
Isn't it a matter which is arrived at because of a view taken presumably democratically that there should be limits in the general interests of the existing population to migration? I mean, I thought that's the reason why we had it.
Well, it isn't a phrase, general immigration control, which is there in Article 8.2 itself. It comes about only because it has been assumed, it has been accepted rather, that states have an entitlement to protect their borders, and in protecting their borders, they'll be entitled to exercise immigration control in the broader interests of the community at large. This may be to do with things such as work, protecting employment markets and so on, or it may be to consider their economic interests.
So those are all rights and duties, aren't they, in a general sense? A state has a duty to look after its existing citizens by
But what one is, or it may be interests of a very specific sort, such as the rights of the community at large to be free from criminality. And when one looks at the cases, the way in which the cases have actually analysed all this is never to accept that the interest of children can simply be overridden simply because of a general idea about protecting the economic rights of the populace. They've always been, in practice, I'll go through them in a moment to explain how they're all consistent with the idea that it's only going to be serious criminality. And yes, on one view, on a broad rights-based analysis, all those other rights are rights-based. But what this is saying is, what this is really pointing to is a much more specific aspect of immigration control, which is more directly engaged or tapping into the rights of others. At paragraph 20, there's an indication of what a determination of best interest requires. Clear and comprehensive assessment of the child's identity, including his or her nationality, upbringing, ethnic, cultural, linguistic background, particular vulnerabilities and needs. So that brings in the relevance of nationality. Lord, can I just go to moving a little faster is to go to the Strasbourg cases. First of all, can I ask you to look at the case of Sen, which is in the Supplementary Authorities bundle at tab 84. See, this is a case where family had settled in Ireland, but one child was left behind. And the court decided that there was a positive obligation on the state to facilitate the bringing of that child from abroad. And why did it do that? It did it because it thought that that was the best way. It didn't use the language of best interests. It was the best way of developing the family life. This is clear from page 82 at the head note at letter G, but more particularly from paragraphs 37 and 40 on pages 91 and 92. And at para 37 on page 91, it says, in the court's analysis, the court takes into consideration the age of the children concerned, their situation in their country of origin, and their degree of dependence on their parents. It cannot, in effect, consider the matter solely from the point of view of immigration. Yes, immigration control requirements are relevant, but by comparing this situation with other persons who've only established family bonds after becoming settled in their host country. And then it goes on over paragraph 40, basically to repeat that's where the head note is taken from. A couple of children in Netherlands, second child born there and a third. These two children have always lived in Netherlands. So what about the first? Is the first not entitled to join them? They say in these circumstances, Sinem's coming to the Netherlands constituted the best way of developing a family life. It's quite clear that what the court is doing is having regard to the best interests principle of the children, not only of the child who's coming from abroad, but also of the two children who are already present in Netherlands. And then importantly at paragraph 41, it says, by only giving the first two applicants the choice, rather like the choice that the AIT gave the family in this case, of giving up the position which they had acquired in the Netherlands or renouncing the company of their eldest child, the respondent's state failed to strike a fair balance. That's paragraph 41.
That's typical language of an Article 8 exercise, isn't it?
It is typical language, but the language is, if I can, without any disrespect, say it's sort of rough and ready. It is the language of balancing.
Yeah.
But exactly what does a balance involve? What does a fair balance involve? It involves looking at, first of all, whether you've considered certain interests in the right way. And the best interest of the child has to be considered in the right way first, in a way which accords with our domestic law as well, including Section 55 of the 2009 Act, which we'll refer to in a moment, in Article 24. It is necessary to look at the child's best interests in that way first. And once you've looked at it in that way first, you will then have acted in accordance with the law. You will then have acted properly. You will then have looked at the best interests of the child in a way which is legally proper. Once you have done that, then, and you have recognized the importance to be attached to it, now you've got the child's interest on this side of the scales, then you have to, on this side of the equation, then you look to see whether there is some competing interest which can knock it out. That's what we mean when we talk about the balance. It's not just throw everything in and look at everything in the round. So this is entirely consistent with our submissions, although the language isn't one of best interests. To same effect is the next case, and this is a situation where the family isn't even already here. This is a situation where one child is abroad, and the idea is to protect Article 8 interests by bringing the child into this country. It's not even about splitting the family apart. It's about failing to bring them together.
This is Tobacco Tekle.
Tobacco Tekle is the next tab. Now, the first page of that actually may appear in my volumes, at any rate, at the end of tab 84.
Oh, yes. Yes.
And you'll see that at the holding 2, it basically takes the same approach as SEN. So yet another example. The paragraph numbers, I think, when it says in holding 2, see paragraphs 11 and 12, I don't think that's right. What one needs to do is actually look at paragraphs 44 and 47 and 48. Which I don't really particularly want to take up time over it, but it's almost exactly the same as SEN.
Yes.
And at 48, it says the Netherlands, paragraph 48, would be the most adequate way in which the family could develop their family life. So this is placing the development of the family's life, having regard to the child's interests, on such a level that what one is looking for is the most adequate way. Never mind considerations of general immigration control. There's no criminality or anything like that here. But general immigration control would have gone against the child. The most adequate way. And then at paragraph 52 it says, because they failed to approach it in this way, they failed to strike the right balance. So when one asks, what do we mean when we talk about striking a balance? Well, that's what we mean. And then there is the case of Bultif. If I can go to, is that there? That's volume 2 at tab 47. I won't go through all of these, but Bultif was a very important case. which involved, I think it's clear from paragraph 11 on page 1181, at the bottom, the court considered that the applicant had been particularly ruthless and brutal, and his culpability was severe. These were violent offences. He'd only been in the country a few years also. And there were no children in this case, so we're talking about, I'll take you to it now to get it out of the way. At paragraphs 39, the court began its assessment and says, second line, "Have the removal of a person from a country where close members of his family are living may amount to an infringement of the right to family life." Then it begins to set out the facts, looks at whether it's in accordance with the law, and more importantly at paragraph 46, whether the interference was necessary in democratic society. Court says for the contracting states to maintain public order, in particular by exercising their right as a matter of well-established international law and subject to their treaty obligations to control the entry and residence of aliens. To that end, they have the power to deport aliens convicted of criminal offences. But as the last few words of that paragraph 46 make clear, it's still got to be necessary, the interference still has to be necessary, that is justified by a pressing social need, in particular proportionate to the legitimate aim pursued. And at paragraph 48, the court has only to limited extent decided cases where the main obstacles to expulsion is the difficulties for the spouse to stay together in the country, stay together, and in particular for a spouse and or children to live in the other's country of origin. Then it sets out, therefore, certain relevant criteria. And it says at the bottom of that page where there are children to the marriage, whether there are children to the marriage, and if so, their age.
In the middle, it says the nationalities of the various persons involved.
I'm sorry, yes.
I mean, it seems to be rather unhelpful to your proposition that they are merit a special consideration. They are obviously one of a number of factors according to this decision.
Well, according to this, it is a list. I agree that it is a list, but this is not beginning to flesh out these considerations. It's heading in that direction.
Well, this again is, as I said earlier, is typical Article 8 exercise. And as you say, there were no children here, so we're not really, the court is really not, as far as I can see, exploring exactly how one applies the primary consideration test.
Yeah. Well, that's right, but it's beginning to recognise that there are nationalities will be relevant. It's beginning in this case, and it concluded at paragraph 53. They looked at the wife's position, that she's a Swiss national, and basically they took the view that she can't reasonably be expected to go abroad. So notwithstanding serious criminality, notwithstanding no children, the fact that this was a Swiss national who knew nothing about, other than the fact that she could speak French, and no doubt they speak French in Algeria, knew nothing about Algeria, that in those circumstances it wasn't reasonable to expect her to go, and therefore the appellant was entitled to stay. The case of, perhaps I can just deal with two cases, Una and Maslov. Una is a case where tab 54, same volume, volume 2, tab 54.
Well, UNA is the one that adds to the Baltif list, isn't it?
That's right, at paragraph 58, it adds to the Baltif list. And as to the best interests, it says, as to the first point, the court notes that this is already reflected in its existing case law, showing that Sen and Tukwabo Tekle were cases to deal with best interests, and is in line with the Committee of Ministers' recommendation on legal status of persons admitted for family reunification. So the important point to be drawn from this case is that although the appellant's children in this case had Dutch nationality, we see that in the summary of the facts in the headnote. This man's offences were so serious and so repeated that this was a situation in which the court felt that nevertheless he ought to be removed. This was a situation in which he'd used firearms in public. He'd killed one man inside a bar and wounded another one outside the bar. And repeated offences. He was excluded, and even when he was thrown out of the country, he managed to find his way back, and they found him working on a cannabis farm. All of that comes through from a close reading of the facts, and so he was thrown out again. Those circumstances, which are about as extreme as one can get, there was room for the court to say, well, in this sort of situation, the interests, even having regard to best interests, the public interest, not in just general immigration control, but in a particular facet of it, that is the need to protect against criminality, was so great that the man had to be expelled.
In paragraph 67, we see the phrase a fair balance again.
Yes. Yes. But as your lordship says, it's a standard phrase, but what you don't get in here is the idea that factors other than immigration control, factors like immigration control will be sufficient. What you do get very clearly is the idea that criminality of this level will be sufficient.
Did that have any impact on what the court perceived to be the interest of the children? The fact that this man had such a criminal propensity?
Well, there may be a passage, trying to see whether in...
But it's contemplated the children would also go with him. That's right, isn't it, Mr. Gill?
I'm sorry, would your lordship repeat that?
The children are going to go away with him.
I don't think so.
I don't
Well,
think so.
64.
Yeah. They talk about that because they're talking about this in the context of the fact that his expulsion is clearly going seriously to interfere in the family life that they all have. But I don't think there's any question of the children and partner necessarily going. I suspect they'll
Not
stay.
necessarily, but I mean, they contemplate it. So, I mean, all I'm really saying is that it doesn't look as if the father was regarded as a threat to his children, which is my lord's point.
He was evidently, paragraph 28, depressed due to not being able to see his children.
Yes,
They visited him in prison.
Visited him in prison, yeah.
it may be that the court has in mind paragraph 64. But that's simply contemplating the possibility. But it's not saying that. But the point is, this is one of those extreme type of cases. This isn't the normal runner case. It's certainly not the sort of case that we have on the facts before you. We have on the facts before you an appellant who's lied. She's made false claims 2 or 3 times about her asylum claim in different identities. That's all. So far as Maslov is concerned, which is the in tab volume 3, tab 55. This concerns a citizen of Bulgaria who, before Bulgaria joined the European Union, long before all the material facts of this case were long before that. He was born in 1984, came there to Austria at the age of 6, and then in his mid-teens committed various crimes with some aggravating features, some drugs also involved, but not seriously violent crimes. Now, in relation to this person's case, or rather, well, not just in relation to this person's case, the court began to look at the position of long-term settled foreign children. And at paragraph 33, they looked at what, even in the case of non-nationals, the position adopted by the Council of Europe. And at paragraph 33, they set out 2 recommendations, which are also independently in the bundle, should you want to look at the full text of them at paragraphs, at same volume tab 65 and 66, but I don't propose to do that now. Paragraph 34 of Maslov, they set out the first of those recommendations. And the second one at 35. And then they begin to take into account the 89 Convention on the Rights of the Child, citing Articles 1, 3, and also Article 40, which I didn't refer you to. The need to promote the child's reintegration, child assuming a constructive role in society, and child's sense of dignity and worth. They also, at para 37, have regard to certain views expressed by the Committee on the Rights of the Child. And at 38, in general comment number 12, they cite from that, and in the middle of the citation, they say that in cases of severe offences by children, measures proportionate to the circumstances of the offender to the gravity of the offences may be considered, including considerations of the need of public safety and sanctions. And then, so far as the European Union law in practice is concerned, they look at some of the directives there, but over the page at paragraph 41 in the Citizens Directive, Council Directive 2004-38, which brings most of these things together, they refer there to Article 27 and 27.2. measures taken, paragraph 41 of Maslow, measures taken on grounds of public policy or public security shall comply with the principle of proportionality, shall be based exclusively on the personal conduct of the individual concerned. And the personal conduct of the individual concerned must represent a genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society. So, it's essentially, in practice, it's serious criminality is what they...
Where was that passage?
This is paragraph 41 of tab 55 of
Yes,
volume 3.
I've got them.
Yeah.
Right.
And citing from the Citizens Directive, which brings together a lot of these directives. And again, seeing how that has unwrapped itself in the case law, paragraph 44, they cite from Orphanopoulos, paragraph 43, Orphanopoulos, and citing from in the quote at paragraph 5 again.
Well, don't you want to draw our attention to Article 28.3?
I apologise. Protection against expulsion. Expulsion decision may be taken against union citizens.
May not be taken against union citizens, except if the decision is based on imperative grounds of public security, if they, A, have resided for 10 years, B, are a minor.
Yeah. Except if it's necessary in the best interest of the child. And
I mean, that really
yeah.
sums up what you're trying to say.
Yeah. In our printed case, what we submitted was that there may be circumstances akin to those set out in European directives. And although the cross-reference wasn't there to Article 28.3, this is, in fact, what I had in mind when that passage was written. But I'm sorry that in the printed case, the cross-reference didn't go through. And then Orphanopoulos, at paragraph 5 thereof, just talks about constituting a present threat to the requirements of public policy. The court began its assessment at paragraph 61.
An expulsion decision is, well, I suppose it's either indefinite or for a period, depending on the particular decision. So that the analogy is, it does remove rights, whereas, so the analogy isn't precise with the present situation. I mean, you're saying effectively this is helpful because it presents an analogy with what's going to happen here in practice, but rights to reside here aren't affected. It is simply that they would be practically useless for the time being.
Yes, certainly. The right exists, but it's pretty pointless.
Yes.
Lord, my lady, rather than reading out large chunks of this, can I just draw attention to the bottom of page 18? Page 18 of 20, sorry, paragraph 68, if you have it on screen.
Paragraph 68.
There's a quote there from Una, which we've all... The bottom, paragraph 55, is important. Then, well, those passages we've already seen from Una, in fact. And
Yes.
at paragraph 74 of Maslow, it says, although Article 8 provides no absolute protection against expulsion for any category of aliens, including those who were born in the host country or moved there in their early childhood, the court has already found that regard is to be had to the special situation of aliens who have spent most, if not all, of their childhood in the host country. And very serious reasons in those situations required to justify expulsion. And at paragraph 82.
Just pausing, 74, is it talking about adults being expelled or children?
Well, that's encompassing adults, and it is not focusing itself on children. It is making a general point.
Yeah.
You might have someone in their mid-20s who spend most of it, if not all, the childhood in the host country. But even such a person has a special position. And we say all the more so if it's a minor, and all the more so if it's a national of the relevant state.
You get onto this at 82 and 83.
Yes. At 82, they clearly bring in the best interests of the child in the context of, refer to that in the context even of the expulsion of foreigners by reference to UNA. At halfway through, or two-thirds of the way through 82, the court considers the obligation to have regard to the best interests of the child also applies if the person to be expelled is himself or herself a minor. And that's referring to the directive, Article 28.3b that we just looked at of the directive. And again, the 1989 Convention. In paragraph 83, the court considers that where the expulsion measures against a juvenile offender are concerned, the obligation to take the best interests of the child into account include an obligation to facilitate his or her reintegration. They refer to Article 40. And they say, in the court's view, this aim will not be achieved by severing family ties or social ties through expulsion, which must remain a means of last resort in the case of a juvenile offender. Finds that these considerations were not sufficiently taken into account by authorities. Some of the court sees little room for justifying an expulsion of a settled migrant on account of mostly non-violent offences committed when a minor. 85, conversely, was made clear that very serious violent offences can justify expulsion even if they were committed by a minor, and they give the example of the aggravated rape and so on. And this clearly demonstrates that the best interests principle is not just being treated as being some relevant consideration to be given weight and thrown into the scales. It is saying it absolutely has pride of place, it is centre stage, it has to be respected. Only in the most extreme cases will it be knocked down, will it be overridden and overborne. So this is entirely consistent with all, the submissions that we have made. Lords, my lady, the final point in relation to this part of the case that I want to make is this, that we know now that the United Kingdom, which had reservations to the UN Convention on the Rights of the Child, reservations in the field of immigration, we now know that those reservations have been withdrawn. And they were withdrawn in, I think, 22nd of September 2008.
What day?
But I'm told 18th of November 2008.
18th November 2008.
8.
Do we have a document that records that, or is it just in a written case somewhere?
There must be one. I don't think it's actually found its way into the authorities, but there, I know there is a statement to that effect, and we will get it if the court would like that. This withdrawal of the reservations, even in the context of immigration, is not without significance. It must, therefore, be apparent that whereas the United Kingdom may previously have been prepared to say, we will simply look at the child's interests as just, of course we will look at them, or we will simply look at them as just one factor, it simply cannot now adopt a broad brush balancing approach like that which it previously adopted. It is not business as usual, since the withdrawal of the reservation and, importantly, the coming into force of the Charter, Article 24, it is crystal clear that the whole of the UN Convention on the Rights of the Child, 1989, has to be followed in English law. At the very least, it has to be taken regard of. We say it's got, since Article 24 is premised upon respect, Article 24 of the Charter is itself premised upon respect for the 89 Convention, in particular to Articles 3, 9, and 12. It must be the case that the withdrawal of the reservations and the Charter, taken also together, impose upon the United Kingdom a duty to follow the Convention. That means that the test that it should apply is not the test of a simple broad brush balancing, but the structured approach that we've tried to set out by giving the best interest some sort of content, some sort of primacy, whether you call it paramount or the primary or a primary, doesn't necessarily matter. One needs to understand the importance to be attached to it. Even if it were paramount, there might be circumstances in which one may say that could be overridden. So it is that structured approach that has to be applied. This requires a significant sea change in thinking in the way in which the Secretary of State sets out his policies and how courts make their decisions.
Now, have we completed the review of the European cases? Because I see in paragraph, at page 21 of your written case, this is paragraph 24, you go on to look at some of the cases in this country where these issues have been addressed. Is that the next place to which to go?
My Lord, I did intend to do that, and I suppose I ought to before I should have done that before I moved on to the point that I'm just on. Yes. But perhaps if the point that I'm just on can be kept in mind, and I'll just finish it off by reference to one thing in due course.
Yes.
Let me just look at the domestic authorities, because it'll make sense.
Yes, well, I just wanted to be quite sure that we've completed now the European.
Well, I've completed the European authorities, but I wanted to draw attention to the domestic authorities there. But,
yes,
my Lord, let me do it in this way, since I'm in fact now referring to this point about the reservations in Article 24. Can I just finish that point and then deal with the domestic authorities?
yes.
So far as Article 24 is concerned, for the reasons that I've just articulated, we say it has to be given full force in domestic law in a manner consistent with the 89 Convention. That calls in the structured approach that we've called for. And the Secretary of State's approach, and indeed the approach of the Tribunal and the Court of Appeal in this case, therefore, do require revision. The Secretary of State has done this much. He has enacted Section 55 of the Border Citizenship and Immigration Act. This is Volume 1, Tab 5. And in this, this says that the Secretary of State must make arrangements for ensuring that the functions mentioned in subsection 2 are discharged, having regard to the need to safeguard and promote the welfare of children who are in the United Kingdom. This is obviously not related to any nationality considerations, it's to every child, to safeguard and promote. These functions.
Which subsection we find this?
Section 55(1).
Yes, I see, thank you.
And then the relevant functions are in 55(2). Any function relating to immigration, asylum, nationality, and so on. So this, we say, must be read consistently with Article 24 of the Charter, which means it must be read consistently with the 89 Convention. If the policy that is brought in, however, which is at tab 10, every child matters, change for children. Maybe thought perhaps not to go we say, is not necessarily consistent with the 89 Convention, because it still just regards best interests as just a relevant consideration, one of many. If one looks at the ministerial forward, one sees that the aim of Section 55 and the lifting of, following the lifting of the reservations was to place all agencies, including the UK Border Agency, on the same footing as other public bodies working with children. That is, to make the approach consistent with Section 11 of the Children Act 2004. And in the introduction at paragraph 2, they set this out again. And then at paragraph 6, it says the guidance is issued under section 55(3). This means that they, that is the person to whom this is directed, must take this guidance into account, and if they decide to depart from it, have clear reasons for doing so. The point that I particularly want to draw attention to, however, the passages start at paragraph 2.1 in part 2, page 14, the page numbers at the bottom. In these passages, whilst the international instruments are acknowledged on the bottom right-hand, paragraph 2.6 and page 14, what 2.7 says is this: UK Border Agency must also act according to the following principles. And the second bullet point, according to the UN Convention on the Rights of the Child, the best interests of the child will be a primary consideration, although not necessarily the only consideration when making decisions affecting children. That approach, simply of treating it as a consideration, not necessarily the only consideration, doesn't begin to give content or structure to the best interests principle.
Now, looking at footnote 13, there, can you remind me, have we got this document in the bundle?
Yes. Yes, this document, footnote 13, is in the bundle at tab 64, I think.
Yes.
Volume 3, tab 64.
Thank you very much, yes. find it page 14, don't we, the bit that's referred to in the footnote.
Yeah.
Page 15 is the relevant bit about a primary but not the sole consideration.
Yes. Yes. It may be the determining factor for some things, so there's a bit of a distinction drawn there then.
Yes, but the point that we make is that simply leaving it in that way doesn't actually begin to give content to the idea of best interests, nor does it give any clarity to the idea which comes through from all the other materials that I've mentioned, that the best interest of the child requires to be placed center stage, and if it is, if the best interest of the child require a certain result, you need an alternative rights-based factor of sufficient gravity and seriousness to override it. Now, this language is not structured enough. That's the criticism we make.
Are you criticising the UNHCR language or just the domestic language, or is there a difference?
Well, the UNHCR language is not, we would say, not sufficiently structured either.
Well, there's a little bit of structure in the 2 bullet points on page 15, which is at least suggesting that there may be some situations in which it will be the determining factor.
I do apologise.
The hint is that in the case we're dealing with, and that hasn't been your submission anyway, that it is not the determining factor, it's not the trump card, but nevertheless, it must be a primary consideration.
Yeah. Not all of what's on page 15 comes over into the domestic document, of course. And in the domestic document, it is much more of a general approach, whereas the UNHCR's document is rather better. But it's the emphasis and the need for structure that I'm concerned about, because unless the court gives some guidance in relation to that, the problem that's going to arise is going to be the problem that we're continually facing, that all of us being unfamiliar with how to look at child rights on the applicant side as well as the Secretary of State's side and as well as those sitting in judgment. Some guidance therefore needs to be given so that people can actually start applying a structured approach, and it's not simply left just as a set of factors, and here's just one of them. In the Secretary of State's approach,
sorry to interrupt you, Mr. Gill, but you were saying that when you look at this paper, matters, it's weaker in structure than the UNHCR guidelines, but you could take the view that paragraph 2.7 is attempting to set out, well, they're put as principles, but it's identifying things that should be taken into account, all in relation to the position of children. And you've got to look at, well, every child matters is a basic point. Yeah. You've got to look at the convention position. You've got to take into account various factors about gender, disability, and so on, consulting the children, minimizing uncertainty, and so on and so forth. Yeah. So these are all good things, yes. You would no doubt say. Yeah. So where is it lacking?
Well, where it's lacking is this, that it needs to start. It needs to say that you start that the best interest of the child has got to be the first thing that one begins to identify by reference to, for instance, some of these sort of factors. They should be consulted and so on. But once one has done that, once one has identified the best interest of the child, then other considerations may be sufficient to override the best interest of the child, but only in certain extreme cases. It doesn't adopt that approach. It just leaves the...
It may be, I mean, it may be because it doesn't agree with it. You can only have a structure if there is something additional that needs putting there, and it may be that the statement made that this is a primary, though not the only, consideration is as far as one can go.
It's not really dealing with immigration decisions at all. It's dealing with how you deal with and look after the children with whom you have to engage in order to discharge those functions. That's what it's dealing with.
Well,
And in that context, no doubt it's a considerable step forward. It's a good thing.
yes, but...
It doesn't say anything about the weight to be given to the best interest of the child when making a decision whether or not to allow the child to remain.
the way...
I mean, in 2.2, it does refer to the application and enforcement of the Immigration Act, including removing from the UK persons who have no legal entitlement to remain in the UK.
That's
I
right.
mean,
Well, I was
I-
looking at that, but I was thinking that you're doing that. And of course, you've got to... But it's not getting at how you did do the decisions.
Well, I wonder, because I mean, I may be completely wrong with this, but I thought that originally the reservation was whether you had to pay any attention to this in deciding whether to remove children. Now that's all been removed. Section 55 comes into force, and this is the guidance given pursuant to Section 55 to tell you how to give effect to that in regard to making decisions whether to remove, or is that wrong?
Well, it says the role of the UK, so Part 2, role of the UK border agency in relation to safeguarding and promoting the welfare of children. It doesn't very clearly start telling us what role what tests or what approach they're going to take in relation to immigration decisions. It says things in 2.7, which is fair enough, but they completely lack the sort of structure that we think ought to be applied, and the tribunal needs to apply if it is to make decisions consistently with the international treaties and case law. Moreover, the UNHCR document itself gives, in fact, a little bit more content than I had given it credit for in page 14, when it talks of the use of the best at the bottom, use of the best interest in the CRC. Term best
This is
interest
back in tab 64, is it?
tab 64, volume 3.
Yes.
At the bottom of page 14, it adopts the use of the term best interest in the CRC and cites in particular general comment number 6. And the approach in general comment number 6, paragraph 86 that we looked at earlier, is certainly not replicated in the Secretary of State's guidance. So although the guidance cross-refers to the UNHCR's guidelines and may be thought to have been intending to be consistent with those guidelines, it doesn't in fact achieve that because it leaves out the structure that comes from general comment number 6, which is
62.
Which is then adopted. Yeah.
I mean, general comment number 6 looms large in Ms. Dodson's case for the intervener, and it's, you know, it's the it's in a sense the high point of your case. Non-rights-based arguments such as those relating to general migration control cannot override best interest consideration. Now, if that's right, that carries you a very long way indeed.
And we say that is, as I've said, that's entirely consistent with the Strasbourg case law. It's in fact entirely consistent with the domestic case law as well, which was the next thing I was going to turn to.
So you're saying that it would have been more respectable, better, if it had included express reference to paragraph 20 of General Comment 6.
Paragraph 20 and 86.
20 and 86?
Yeah.
Yes.
It sort of does it by cross-reference to one document to another.
It's 62, tab 62.
62.
The value of paragraph 20 is that it gives guidance as to how you assess the best interests, which you say is the necessary starting point.
Yeah.
And then you get on to 86, which of course is dealing with the application of that in issues about return and so on.
That's right. It may be that's what they intended, because it's footnote 13 does refer to the UNHCR guidelines. The UNHCR guidelines do cross-refer to General Comment number 6.
Yes.
But it's not repackaged like that.
No, you've got to do a bit of excavation before you actually get there.
That's right. And that ought to be made clear, and if it can be made clear in the court's judgment, we think that that would be a significant step towards assisting decision makers to make properly structured decisions, which is something that Lord Justice certainly on more than one occasion in relation to Article 8 has called for.
And all of this is linked back, of course, to Section 55 in the 2009 Act, which is what this paper is talking about.
That's right. That's right. The duty to safeguard and to promote.
Yeah.
And so that is, I think I've got two things to deal with. One is the domestic case law, and then the Shen arguments in relation to nationality. So far as the domestic case law is concerned,
well, would it be convenient to address that after the short adjournment?
Certainly.
Very well. We'll look forward to seeing you again at 2 o'clock.